everyone, I'm Sona Tatsians. I'm an estate planning attorney, and I wanted to talk to you about a particular case that came across my desk today. So I met with a really lovely couple that have been together about 7 or 8 years, and they live together, they own a house together, and they also have a baby. Except they have these ideas of if something was to happen to one of them, how their assets will be passed. And they started talking to me and they said, if something happens to either one of us, everything will go to the survivor, then it will go to the baby. And then I started asking them questions about how they hold title to their assets. And turns out they're not married, which is perfectly fine. But what happens is they have these ideas of, we've been living together, we have really common law marriage, we've been together for so long, we have a house together, we have a child together, obviously everything will go to the survivor then to our child. So they have these preconceived notions of how things will be passed, but that's not what the law says. The law is very black and white on how they consider disposition of property. You're either married or you're not. You could have 5 houses together, you can have 5 children together, they really don't care. So for example, for this couple, they thought clearly they've been living together, they're considered to have a common law marriage, they're, everyone around them thinks that they're actually legally married, but that's not the case. And also after digging into this further, I find out that the house is only in the boyfriend's name and not the girlfriend's name, because what happens is when they were actually applying for the loan, she just had the baby, was not working, and wouldn't qualify for the loan, so they only put the house in his name. So given what they told me, I had to be the bad guy and say, well, you guys have an idea of how things will be distributed, but that's really not what the law says. The law says this: if something was to happen to the boyfriend, the house is only in his name. It will go through probate. During the probate process, his heirs at law will inherit the property. And guess what? The girlfriend is not an heir at law. She's not a spouse. She's not married to him because California does not recognize common law marriage. Again, they have an idea that they've been living together, they have built a house and a life together, that they're in essence married, but that's not what the law says. It's very black and white. So what's going to happen is if something was to happen to the boyfriend, it will go through probate and his heir would be his child. And the child is a minor child. What happens is the child will not be able to inherit the property, and it will go through a guardianship process where the mom will be appointed as the guardian of the child's asset, and she would have to take care of the asset, whether it's a house or any other property that dad has left the child until the child is 18. So how can we remedy the situation? Well, one of the things to do is he can create a trust. He can put the property in the trust, and he can name the girlfriend plus the child as a beneficiary. So if he wants to ensure that the girlfriend gets the property, you want to make sure that you have it specifically in writing. The other thing that he can do is he can actually add the girlfriend to be a co-owner on the property. The problem with this is because they're not married, once he adds her name to the property, half of the property will get reassessed, and all of a sudden he may have to pay also gift taxes on gifting her half of the property. So these are transactions that people participate in all the time, not knowing that there's tax ramifications, and then there are all these other ramifications that could follow from you thinking something is the way it is, but that's not what the law says. So the lesson I'm trying to get to you today is make sure to know how you hold title, make sure you understand the legal ramifications that follow from it, and make sure to speak to a professional. You don't have to be married, or you may want to get married, but actually know what your rights are, know what rights you're gaining or giving up as a result of doing that. If you have any questions, I'd love to hear from you. Leave me comments. I'll go ahead and answer your comments, or feel free to email us at our law firm at info@linklaw.com. Thanks. See you next month. Bye.